Hello, sir. Very welcome to you. So, shall we start the session, sir?
Yeah.
Okay. Good evening, everyone. I, on behalf of Legal Expatriate, welcome you all on the second day of our 5 days online course on Art of Drafting Domestic Violence and 498A matters. It is my pleasure to introduce our esteemed guest speaker for today's session, Professor Prithwish Ganguli, a highly accomplished legal professional with a diverse academic background and extensive experience in the field of law. With an LLM degree and specialization in international convention and maritime law, Professor Ganguly possesses profound expertise in international legal frameworks. Additionally, his diploma in psychology adds a unique perspective to his understanding of human behavior within the legal context. Professor Ganguly holds significant certifications, including UNESCO certification on AI and the rule of law and Ellison certification on GDPR, highlighting his in depth knowledge of emerging legal challenges in the digital era. As a, as a professor of practice in Brainware University, Department of Law, and chief editor of Law Updates, Professor Ganguly imparts valuable knowledge and ensures dissemination of up to date legal information. Furthermore, his role as World NRI Council Legal State Advisor for, for West Bengal showcases his esteemed position within the legal community. We are truly honored to have such an accomplished and inspiring guest speaker with us today. Please join me welcoming him. Now, before handing over the session to our speaker, I request you all to keep your mic and camera off so that it would not create any hindrance during the ongoing session. Over to you, sir.
Hello, good evening, everyone. It's my pleasure to be again on this esteemed platform. Our today's topic is Art of Drafting of Domestic Violence and 498A matters. So before going to the subject, today's discussion, I want to share few things like the few points to note while we start drafting of any domestic violence matter or 498A matter. Keep it in note that the first drafting is the first pillar, basic pillar, the foundation of a case. So when we are filing any complaint petition or letter of complaint to any police station or before any court, our complaint should be, our drafting should cover all the four corners of the matter. How to do that? In a domestic violence case or in a 498A case, before starting that first drafting, we should give patience hearing to our clients. It may require two sessions, 3 sessions. It may require, but we need to know every minute points of her matter. And while you hear your client, while your client is saying her experiences, her problems, everything, you need to note, if possible, month-wise, date-wise, time-wise, as much as specific you can. You have to note her every specific matter, complaint, whether she was assaulted, why she was assaulted, what is the source of such domestic violence. I mean, what is the reason for that what action she has taken, whether she has filed any prior complaint to the police station or in any court, what is the socio-economic status of both the parties, what is the income of the wife, what is the source of income of the husband and his family members, how many children they have. You have to note every minute point, and literally you have to take note in a paper. Don't try to keep it in your mind, don't try to remember it, note it in a paper, so that while you will start drafting, the entire matter will be before you. You will not miss any point. It is important to note, you will also appreciate that after hearing a matter or after reading a matter, whenever you are reading a book or you are listening this session, today's session, whatever I am telling, after the end of the session, after 22 minutes, you will forget about 60% of what I have told. Only 40% you will be able to remember. This is psychology. So don't try to keep it in your brain, keep it in paper, so that at the time of drafting, you can incorporate 100% of the matter of your client in your petition. Now, if I come to the main point, the petition, how to draft it. In a petition for Domestic Violence Act or in any petition under section 156 clause 3 CRPC for an order for FIR under section 498 AIPC, first of all, we need to give introduction of the parties. What is my status? I am the wife. Where I am living now, on which date the marriage was solemnized, under which act the marriage was solemnized, whether it is Hindu Marriage Act or Special Marriage Act or whatever. Place of marriage, whether the marriage is registered or not, whether the marriage was after the marriage, whether the marriage was consummated or not, whether the parties were blessed with children or not. If they are blessed, how many children, what are their names, what are their date of birth, everything. This part is called the introduction. Here, in short, we are explaining, we are telling about myself, I am telling about my other side, and I am telling about our family members and our marriage. Now, the next part will be the facts part. That means what I want to say, why I am before the court, what is my complaint. Every single incident should be in a single para. Don't club 4 or 5 incidents together in one para. Make your paragraphs very short. While writing your complaints, try to be specific as much as you can. Mention place, date, time, day, and who were present at the time of the incident. Try to be as far as possible specific and be cryptic. Don't try to elaborate any complaint. Don't use too much of adjectives. just state your complaint. I was assaulted by Mr. Ram on such and such date, at such and such time, at such and such place, in presence of ABCD. I was assaulted by a wooden stick on my back. This is your complaint. Just write that. After the incident, I was so injured, so much grievously injured that I went to such and such government hospital at the emergency counter department, and I got such and such treatment there. The ticket OPD ID number is this, dated, time. Just mention everything. Don't elaborate. Don't make story. Give the crux of the matter with full of specification. Now, next point. Try to state the reason. What is the reason behind this domestic violence? Whether it is under Protection of Women under Domestic Violence Act, or it is the complaint under Section 498A IPC. What is the reason behind that? What you think? It may be in demand of dowry. It may be in demand of anything else. It may be that the husband is not of sound mind. It may be that husband every day returns home in drunken condition, and on protest she is being assaulted. So what is the reason? What do you think the reason of your husband, of your in-laws behind their such acts and activities? Without any reason, a crime cannot take place. So assign the reason. Then come to the point. Next, the cause of action. When the cause of action first arose, what do we mean by cause of action? Cause of action means the reason. I am filing a case in court. That means I am going to take some action. I am praying before the court to take action. Now, what is cause of action? What is the reason that I am praying before the court to take action in respect of some incident, in respect of some person, against some person? What is the reason for that? And when did such cause first arose? The next point is jurisdiction. Whether the place of occurrence or your place of residence is within the jurisdiction of the court where you are going to file this complaint under Section 498A IPC or Protection of Women from Domestic Violence. Now, next point is the relief. What relief you are praying before the court? For what reliefs you are filing this petition? Whether you are willing to get some protection or some residential relief or some monetary relief or child custody, or you want to record the crime so that the criminals may be punished. What is the relief you are asking for? And the next part is your prayer. What are the specific prayers? Now, when it is a petition under Protection of Women from Domestic Violence Act, you have the option to pray for multiple relief. You may pray there for residential order. you have the right to stay in a shared household. So you may pray for an order for staying in the shared household. In plethora of judgments, our Honorable Supreme Court defined what is a shared household. So you, as a wife, she has a right to stay in a shared household. As a wife, she is entitled to get a residential order. She is entitled for monetary relief in terms of maintenance or any kind of monthly payment, and she is also entitled for compensation. So to pray these reliefs, your averments, your petition must contain some more specific information. What are that? The present residence of the husband, the ownership of the residence of your husband. If your husband is residing at his own residence or in a rented accommodation or in a residence owned by someone else, what is the financial status of your husband? What is his income, whether he is in service or he is in business or he is in any profession, and an estimated income as per your assumption or whatever you have heard. It is not possible for the wife to state the exact income of the husband. Wife can only assume or guess, or she may state that I have heard from my husband that he earns 5 lakhs rupees per month or 10 lakhs per month or 20 lakhs per month, whatever that is. And now come to your point that whether you are employed or unemployed, if you are employed, what is the status of your employment? What is the quantum of salary you are getting from your employment? Whether your job is permanent in nature or not? Whether you have any children, if you have children, under whose custody the children are. If the children are under your custody, you can also claim for maintenance for your children also. In that case, you have to state that what is the age of these children, in which school they are studying, in which class, what is the school fees, what is the school bus fees, what are the other school related expenses, what are the other extracurricular activities like swimming, drawing, games, anything. And as far as possible, you have to give these expenses under specific heads. Now, you can claim compensation also for the losses you incurred due to this domestic violence. Say, for example, at the time of marriage, the wife used to work in a multinational company and used to earn rupees 2 lakhs per month. But after 6 months of marriage, due to some matrimonial issues and otherwise, wife was compelled to leave her job. So, after leaving the job, wife has been suffering from losses at the rate 2 lakhs per month. So it is her loss. And she has incurred this loss due to the domestic violence or anything else happened in her matrimonial home. So on various courts, the wife is entitled to claim compensation also along with maintenance. Note it, maintenance is separate thing, compensation is separate thing. Maintenance is per month, compensation is one time, and along with that, wife is entitled to claim litigation cost, the expenses that she has to incur for continuing this case. So all these things a wife can claim in a petition for domestic violence. So to claim these reliefs, the wife should give as far as possible specific information. The drafting should not be voluminous. Drafting should not be 50 pages or 100 pages. No, it is not required at all. The entire petition maybe to 4 to 5 pages, that is enough. No issue. A senior lawyer of our Alipur court, Kolkata, I want to mention his name. A very nice person, very senior. He is now aged around 70 years. In one case, he was in my other side. His name is Advocate Sushil Chakraborty, a very senior lawyer in Alipur court, and still now he is in practice. And I learned many things from this person. I have deep respect for him. In that case, he was against me. I was for the husband, and Advocate Sushil Chakraborty, I call him Sushilda. Sushilda was for the wife. The entire petition for domestic violence, still I remember, was of 3.5 or 4 pages, including verification and affidavit, cost title, everything. So nice drafting, so nice drafting. He incorporated everything. He incorporated every point. But the entire petition is 3.5 pages to 4 pages. Finish. And in that case was continued for around 3 years or so. Continued in 5th JM, Alipur court. After that, the matter was settled between the husband and wife, and the role of Advocate Sushil Chakraborty is there for the settlement. He forced both the parties to go for settlement. Whatever, what I was telling. So the drafting, it is not required that the drafting must be voluminous, huge. Be specific, be cryptic, and don't exaggerate anything. Don't repeat a point. Now, in the year 2020 or 2021, in a judgment, Rajneesh versus Neha, I think you all are aware of it. You all are very much updated with these matters, and I think you all are aware of it, that Supreme Court has ordered that both the parties in a matrimonial suit or matrimonial case, if it is 125 maintenance case, or if it is domestic violence case, or it is in any matter where there is a maintenance claim, both the parties have to file one affidavit. That affidavit is called Affidavit of Assets and Liabilities. The format has been specifically given by the Honorable Court in the said judgment. You will get that in that particular judgment, Rajneesh versus Neha. Lots of information you have to disclose in that affidavit. It is your bank statement, it is Many of you are writing many things in the chat. Right now, I will not reply anything. After 7:15, I will talk to you. There will be an interactive session and I will try to reply your all questions. Please keep patience. Now, in that affidavit of assets and liabilities, as per the format of the Honorable Supreme Court, lots of informations of both the parties have to be disclosed. Like last 3 years income tax return, if the parties are filing income tax return, their 3 years bank statement, their bank statement at the time of marriage, 3 years prior to the marriage, if they have any loan, all the loan details, loan statement, whatever are their mutual funds or shares or fixed deposits, anything, everything you have to disclose. Along with that, you have to disclose all your liabilities. Liability means your personal ailments, that is your liability. You have to take medicine of rupees 2,000 to 3,000 per month, that is your liability. You have to take care of your aged parents and you have to spend rupees 20,000 per month for them at least. That you have to say. I should not say that taking care of the parents is liability. I should not say that, but that expense is your liability. That 20,000 or 30,000, whatever you are spending for your parents, that amount will go to your liability side in a balance sheet. You have to mention that. Whether the children are in your custody, what are the expenses, all the bills, vouchers, everything you have to attach. And in that particular affidavit, you have to attach every supporting documents. Along with that, you have to attach your, and you have to disclose your PAN card, PAN number. This is the very basic things for drafting a petition under the provisions of protection of women from domestic violence. In a petition for 498A, just you have to disclose, state very precisely and to the point the crime that occurred. You have been assaulted, you were assaulted on Monday at 6 p.m., on Tuesday at 9 p.m., on Wednesday at 7 p.m. You have to specifically state that. And on the first day, you were slapped. On the second day, you were bitten by scale. Be specific. And in the prayer portion, in any petition under section 156 clause 3, for an offense punishable under section 498A IPC, the prayer should be, you may write it, you may note it, that an order be passed upon the concerned police station. Concerned police station means, number one, either under the police station where the offense was committed, or under the police station where the wife has been residing or is residing at present. So direction upon that particular police station, please state the name of the police station, officer in charge of such and such police station, to register the present complaint as an FIR and to start investigation and to file a report, furnish a report before your honor. Another point you have to mention here, that you have not filed any other petition before any other court or the same court under the same cause of action. That means it is not the second petition. You all know very well, better than me, that double jeopardy is prohibited in our constitution. You cannot prosecute a person twice on the same offense. So registration of 2 FIR, if you file consecutive complaint on the same cause of action, same incident, that is illegal. So you have to state that this is your first complaint and you have not filed any other complaint before this learned court or before any other learned court. Every petition must be supported by affidavit. That may be petition under section 156 clause 3 for FIR under section 498 IPC, or petition under the provisions of protection of women for domestic violence. In the Domestic Violence Act matter, there is some other provisions also that you should know. The wife is entitled to claim interim maintenance, interim relief, better to say, interim relief. Even the wife can claim ex parte relief in case of extreme emergency. What is that? Just after filing the case, you can file another petition and move before the learned court. That situation is so serious that immediate relief is required. That may be for monetary relief or for residential relief or for any protection order. So considering that aspect, court is empowered to pass order ex parte basis if situation so deserves. Alternatively, court will ask you to send notice to the other side, and after that court will hear both the sides and court will decide accordingly. So a case will go on for 2 years or 3 years. How can I survive in this period? Where I will stay? So as interim relief, the wife is entitled to claim for monetary relief and residential relief and protection order as interim relief. For that, you have to file another affidavit that I am praying for interim relief on such and such ground, and such interim relief is prayed by me. I am praying for number 1, maintenance monetary relief. I am praying for residential order. I am praying for protection order. These interim reliefs we can pray if those are required at all. And to pray these interim reliefs, you can file one single affidavit along with the complaint petition, and in the affidavit you have to just say that these interim reliefs are required for me to sustain during the pendency of the case. Now I am going to read the questions in the chat box. You may ask.
Thank you so much for such an enlightening session, sir. Please allow us to read out the sessions to you, the questions to you.
Sorry.
Sir, please allow us to read out the questions to you, then you may give the answers to the same.
Yes, sure. But I'm seeing here that someone is writing about PPT. I'm not concerned with any.
Yes, sir, that is not concerned with this session. That is why I ask you that please allow us to read the selective questions to you.
Sure.
So I just read the question for you, sir. So first question is from Vaishali Vaishnavi. So she asked that can wife claim marriage function money as compensation?
No, there is no such provision in law where the wife can claim marriage function money from the husband. That is not a part and portion of the term compensation. Compensation is only for the damages you suffered during the course of your marriage. Marriage function money is not allowed. Next.
Next is from Siddhant Singh. He asked, is wife always entitled to claim compensation or in specific conditions only, like she was doing job in multinational company? Can wife claim compensation for mental cruelty?
Yes, definitely. I missed this point. Sorry. And thanks to Siddhant for reminding me this point. Wife can claim compensation for mental cruelty also. The mental pressure, the mental trauma that she has suffered due to the domestic violence at her matrimonial home, wife can also claim compensation for that also.
Next is what things are mentioned in draft of husband side? How to argue from husband side? Sir, will you share some real case examples?
Very nice. Very nice, and thanks for that. I want to share one specific case. The case is still going on, so I will not mention the name of the parties. I will just state the facts of the case. The case is going on in Srirampur Court, Hooghly. It's a domestic violence case, and both the parties are working in a multinational company in IT sector. Husband, admittedly, husband is employed, and the wife is a BTech in computer science, and she used to work. But in court, she said that under the mental trauma and mental pain, I was not able to continue with my job, and finally I have to leave my job. And she produced one document by which she showed that she is not in that company where she used to work earlier. And she stated that right now I am unemployed and I need maintenance.
Okay.
So we were clueless how to fight that, but I presumed that it's not true. Wife is working, but she is suppressing her income in order to squeeze money from the husband. But how to unearth it? I filed a petition in court praying for an order upon the wife to disclose, to file Form 26AS of income tax of the wife. Note it. Form 26AS. It is available online in the income tax portal of everyone. If you log in your income tax portal with your PAN card, you will get Form 26AS. You will be able to download it. What you will get in Form 26AS? Only the TDS. Say you have a bank deposit of 50 lakhs and you are getting interest on that. So bank will deduct TDS from your interest, and bank will deposit that TDS amount to the government of India, and that amount will reflect in the Form 26AS. So all the TDS, all the tax deducted at source, all the amounts and the name of the company or person who is deducting the tax will reflect in Form 26AS. Now, if you are in service, if you are employed and you are getting salary, so your salary is definitely subject to TDS, and your company name will be there in the Form 26AS. The wife raised strong objection against any order for producing Form 26AS. But the learned ACJM perhaps guessed the point and passed order, directed the wife to produce the Form 26AS immediately within 7 days. And after 7 days, when the wife produced the Form 26AS, we all saw that the wife was at that time, after leaving the previous company, at present, she has been working in IBM. The case finished. Now, 340 proceedings has been started against the wife for making false statement before the court. Thanks, Vaishnavi, for reminding me to share this real case example. What's
So let
next?
me see next question, sir. Yeah. So what if husband turns up, then what if husband never turns up? Then what happens to submitting affidavit?
What if husband never turns up? Then what happens to submitting the affidavit? No issue. If husband neglect to appear before the court and neglect to file his affidavit, it is his responsibility and the case will go against him. Court will believe whatever I am stating backed by my logic. It is the responsibility of the husband. Wife's case will not suffer for that. Okay. Next.
Can police arrest in 498A without issuing 41A notice? A notice?
Not possible right now after the Supreme Court order in a case of Bihar. I forgot the name. What is that?
Arnish Kumar, sir.
Right. Anish Kumar. Yes. Not possible at all. Police is bound to issue 41A notice in a 498A case. And even not only 498A, but if the punishment is up to 7 years, police will have to
What
issue
is 41A notice?
41A. Yes, please.
Sir, what is 41A notice?
What is 41A notice? Do you have CRPC in your hand, please?
Okay, I can open CRPC in the bare.
Please open. I am here. Please open.
Wait, sir.
Go to section 41A. Now read it out. Read it loudly, please. What is your name, sir?
Sir Siddhant Singh.
Siddhant. Please, Siddhant.
Yes, sir.
Read it.
41. Notice of appearance before police officer.
Yes.
The police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed a cognizable offense, to appear before him or at such other place as may be specified in the notice. Where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. Where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. Where such person at... Yes, sir. Yes, sir. Got it.
Clear? Any doubt?
Yes, sir. No, sir.
Thank you. Thank you. Nivedita Dwivedi, husband never turns up in case. What to do in such situation? Go for expert hearing. File petition before the court for proceeding ex parte. Your case should not suffer if the husband neglects to appear in your case in the court despite receiving the notice. Okay.
Next question is if
498
shall I read for you, sir?
Yeah, both the cases can be filed because relief in 498A and relief in Domestic Violence Act case, protection of women in Domestic Violence Act, both two are separate. In 498A, there is no relief for the wife. Here the wife can pray for punishment of the husband. But in protection of women in domestic violence, wife can pray for maintenance, for residence order, for child custody order, for protection order. So on the self-same cause of action, case under section 498A and under the provisions of protection of women under domestic violence, both are applicable. Okay.
Next question is, does anyone else other than wife file for interim maintenance in domestic violence case?
Yes, mother can file, sister can file. Though I mentioned the word wife repeatedly, but it's domestic violence. That means you must have the relation, you must be in domestic relationship. Whoever is in domestic relationship with you, say my elder sister is in domestic relationship. We live, I along with my elder sister live in the same flat, and I torture upon my elder sister for her property. My intention is to get her property. So my elder sister can file case against me under Domestic Violence Act. Next
question is, can wife ask for maintenance or compensation even if she is earning well?
Wife can claim compensation even if she is earning well, but cannot claim maintenance.
So we have so many questions, sir. So I asked all the participants to ask directly to the speaker so that we can.
I am reading the chat. Wait. What is the limitations for filing DVC after separation? No limitation. No limitation. Every day you are in separation inflicts mental trauma on you. So every day gives rise of a fresh cause of action to file case. So practically, in practical sense, in reality, there is no limitation. Next, Arya Chavan. What wife can do if police is not cooperating to register FIR in 498A case? If police is not cooperating to lodge the FIR, to register the FIR, the wife can go to the superintendent of police or commissioner of police to file the same complaint and wait for 15 days. And after that, wife can move to the nearest magistrate's court under section 156 clause 3 CRPC. Clear? Dr. Hanuman Singh, can wife claim house in the name of mother-in-law? Yeah. If it is a shared residence, the wife can claim right to residence over that property also. Next, Arman. In a situation where wife is physically abused and had been thrown out of the matrimonial home, along with that she was also asked dowry from time to time. In this case, how to proceed with the case, like first to file 498A or 125 or DV Act, or first file 498A and then I will suggest to go for DV, because ultimately, end of the day, whatever relief is available under section 125 CRPC, there is maintenance. That maintenance part, that maintenance relief is also available under DV Act. Along with that, you will get many other options also. You have got more options in DV Act case. So I will suggest to first go for 498A, then skip 125 CRPC and go for DV Act case. I think that will be that will give your client much better relief. Next, Mr. Raj Simha. Any case where earning wife can give maintenance to unemployed, not working husband? Yes. I will not say that there is no provision for that. I will not say that. Husband can also claim maintenance from wife, but it's very rare case and remote chance as per our present situation, or better to say convention. Mr. Rao, again, if the cause of action is from another state, can it be filed where the wife presently stays? Yeah. There is a judgment of the Honorable Supreme Court that the wife carries his jurisdiction with her. But the wife is at present residing, wife can file case in that jurisdiction. Maybe the offense committed in other state, in other country, or wherever. Wife can file the case where she is right now residing. How to deal with false 498A, 125 and domestic violence case? Mr. Mukesh Gupta. Mr. Gupta, are you there?
Yeah, I'm here.
How to deal with false 498A, 125 and domestic violence cases? This is your question, right?
Yeah.
You have to prove it at the time of trial, at the time of evidence. There is no other option. You have to prove that the 498A case is false through your cross-examination. For cross-examination, you have to learn the art of cross-examination. Cross-examination is a very critical part in a criminal trial, and you have to follow the senior lawyers of your courts, how their cross-examining in their cases. You have to follow that. After following them for 5 years or 10 years, you will be able to learn the actual pattern, actual style of the cross-examination, and along with that, you have to study the Evidence Act thoroughly and thoroughly. Only by this you will be able to crack the wife during cross-examination, and you will be able to help your client by proving that the case is false. Okay. Quashing of proceeding under section 482 CRPC to quash false cases. Very tough, but you can try. If you have to, quashing basically depends on if prima facie taking the complaint as if true, no cognizable offense can be found. In that case, quashing can only be possible. For quashing matters, I will advise you to study the Bhajan Lal case, Punjab. Bhajan Lal versus State of Haryana. A landmark case on this particular point. Next, Chaukaji Rao, can wife claim maintenance in 125 and DVC? Yes, wife can claim maintenance under 125, under Domestic Violence Act, and under many other provisions also. But as per the recent Supreme Court judgment in Rajneesh versus Neha, the Supreme Court clearly stated that the highest amount to be paid. Say in 125 case, court ordered to pay 10,000, and in domestic violence case, court ordered to pay 15,000. So the husband is bound to pay 15,000 only, not 10 plus 15, 25,000. Husband to pay the higher amount, that is 15,000. Okay. Mr. Mukesh, if wife has 5 to 7 lakhs in terms of EPF and 80C investments and not working currently, still wife can claim interim maintenance. Yes, can claim. If I don't know what is the revenue income of the wife in this case, you said that 5 to 7 lakhs in terms of EPF. You said EPF, that means wife is earning. I don't know the salary. And 80C means if it is 80 crore or 80 what? I don't know.
Sir, I'm repeating my question. So my question is, if she was earning before marriage, and if she has around 5 to 7 lakhs in either in EPF or in ATC, I'm talking about the investments, ATC investments. So still she can demand for interim or maintenance.
Yes, she can, if her husband's income is much more than her income. In that case, she can claim.
Okay.
But in such a case, interim maintenance should not be allowed.
Should not be allowed.
Interim maintenance should not be allowed, and the matter of maintenance will be decided at the final hearing.
Okay. And intentionally, if she's sitting idle to get the money from the husband, so the court will see that part or not?
Yeah, you can show that she has sufficient educational qualification to earn.
Okay.
She used to earn.
Yeah.
She has the capacity to earn, and she is sitting idle. There is one Supreme Orissa High Court judgment that the provision is not to make the wives idle, sit idle. The provisions of the law for maintenance is not to make the wives to sit idle at home and use the marriage certificate as ATM card. Most probably it is the observation of the Honorable Orissa High Court. Next, Simon, how husband has transferred all his properties in the name of his major son from second wife. How wife can claim maintenance from her husband? What are the avenues for her to proceed for maintenance? Sriram, are you there, Mr. Sriram? I need to understand the question. Mr. Sriram, are you there?
Yes, sir.
Please explain your.
Husband has first wife. He has not given divorce to first wife, and he got married to second wife, and now second wife has major children, and first wife has filed maintenance application under section 125, and husband has transferred all properties in the name of second wife children.
After filing of the case or before filing of the case?
Wife has not, she is not aware about it, and she don't have any other documents that he has some properties or so and so bank amount, anything she is not aware about at all, because they are like they separated after with each other, and he has got married with second wife.
Challenge the you have the option to get the bank statement and property details of the husband at the time of the marriage and preceding 3 years from the date of filing of the affidavit of assets.
That is if the husband was claiming or he was having salary, but if he is agriculturist and he has 40 acres property land,
okay,
he had 40 acres land, but all land he has transferred in the name of his son. So
find the
that
deed.
can,
Search out that deed of transfer and produce it before the court to show that in order to avoid the payment of maintenance, husband has transferred all the properties in the name of his son from the second marriage. He did this just in order to escape from the payment of maintenance to the first wife.
would this amount to claiming right over property belong to her son, stepson? Would that mean like this, expecting like this from court?
If the husband siphoned his income or properties in the name of anyone else in order to avoid the payment of maintenance, in that case, that transfer will not help him to evade the payment of maintenance.
Okay, sir.
Got my point?
Thank you, sir. Yes.
Welcome. What remedial steps can be taken to discourage misuse? What happened?
त्याला कसं आहे अजून पुढे विचारलं असतं ते म्हणलं असतं कसं काय
श्रीराम तुमचा माईक चालू आहे.
What remedial steps can be taken to discourage misuse of well-intentioned clause? I could not understand the point. I could not understand the question. I am moving to the next question. What if wife claimed domestic violence just on fake story and no evidence for a story? It's a very nice case for you. He will win that case. At the time of evidence, at the time of cross-examination, you can prove that. No issue. I'm moving to the next question. Poco C31. What if the husband insists wife to take loan with her documents and husband withdraw the money from bank ATM? Can wife file DV on the ground that wife caused him financial cruelty? And how to, not financial cruelty, financial loss. Husband forced her. Under the pressure of the husband, the wife was compelled to take a loan in her name from the bank, and husband misappropriated the entire amount. This should be your version. The wife's version. Can a victim claim both the 125 maintenance relief and, yeah, I told it earlier. I'm skipping it. Wife is earning 50K and husband is earning 50. Will the court? No order, because both are earning and the quantum of income is same. So there will be no interim order. Husband has transferred all his properties in the name of his. I have replied this question earlier, Mr. Sriram. DV can be invoked against minors if that you want to file DV against minor, that will go in juvenile justice. One of my known case is going on for 5 years, but the husband has never appeared in case nor paid any maintenance of her and her 3 children. Whenever warrant is served, he pays to the police and the warrant returns unserved. What to do in this case? Can ex parte order be issued? Definitely. Definitely it can be issued. File prayer before the court to send a non-bailable warrant. You can file prayer for that also, and I think a non-bailable warrant will give proper lesson to the husband and to the police officer also. How to save yourself in getting false 498A at the police station level? I think I should not answer this question at this platform. How to save yourself in getting false 498A filed at the police station level? You will find a hint of this answer in the question of Nivedita Divedi. Read her question, you will get the answer of this question. If husband files divorce petition, can wife claim? Yes, definitely. Wife can file maintenance. Women are entitled to maintenance under section 125 CRPC, but when it comes to men, only Hindu men can get maintenance under section 24 of HMA, but there is no guarantee. So how to deal with? If you want to deal with this matter, you have to deal it in parliament. There is no other option. You, me, we are not lawmaker. We just follow the law. If there is no law, then you cannot do anything. If husband is not working intentionally, wife is teacher, can the wife claim maintenance? If wife is a teacher, that means the wife is earning, so she cannot claim. Unless there is a huge difference of income between the husband and wife. Can 498 a 125 DV be quashed if there are false cases? Definitely. If prima facie it transpires that the case is false, it can be quashed. The very interesting case in this regard is Bhajanlal case, landmark case. Note it. What if husband transfers his property and money to someone during pendency of litigation? And I have replied this question earlier, sir.
Sir, Mukesh, so on last answer, I would ask one thing. So if the false cases are means filed by wife, so still she can claim for maintenance or interim?
She can claim for everything.
Still she is filing false
You can
cases.
claim for your kidney also.
Okay.
That is not an issue. But if it is false, you will get every opportunity to prove it false.
Okay. Means if you are proving it false, still we need to pay the maintenance or not?
interim maintenance may be allowed, because at the time of passing the interim maintenance order, court will not go to the merit. Court will just see that if there is a valid marriage, number one, if the wife is earning, number two, if the husband is paying any amount bona fide to the wife. Only these 2 or 3 points court will take into consideration at the time of passing order for interim maintenance. But at the time of final order, if you can prove that all the allegations are false, no maintenance order will be passed. That is for sure. Lots of judgments are there on this point. Lots of judgments.
Okay, so we can go for to High Court as well for the question if we don't want to.
Read Bhajanlal case.
Bhajanlal case.
Bhajanlal case, landmark case. He will get your answer.
Okay, Bhajanlal case for Delhi or some other
Supreme Court.
Supreme Court. Okay.
Yeah.
Okay.
While divorce, only maintenance amount is given to wife and also property of husband. Mr. Raj Simha, I could not understand your point.
So the question was during the divorce, if it's proven that maintenance has to be given by husband to the wife, there was an order or degree, and also wife can claim the property of the husband.
No, not the property.
Okay, so
Not
during
the
the
property.
divorce, max it can come only the maintenance, no property.
That amendment is pending in the parliament.
Oh.
Next, so my question is, if wife goes to file the case, then what legal action can we take before filing the case, before drafting? Nothing, no option. After filing, you can take action, not before filing. What do court normally considers in 498 DV and 125 cases? Brief 2-3 points. Mr. Ajay Thakur.
Yes, sir. Yes, sir.
I could not understand your.
Just wanted to know that what court sees during the proceedings in 498A, 125 and DV. What the main point that court considers? Means court considered the valid marriage, the
At the time of interim or final? At
the time of final order. Sir.
Final. Court will consider the validity of the complaint, whether the complaint is true or not, whether the allegations of the wife against the husband and the in-laws are true or not, and nothing else. Your duty is just to challenge the letter of complaint or complaint petition and leave no stone unturned to prove the complaint as false.
Okay, sir.
Mr. Siddhant, can a brother be prosecuted for violence on sister? Definitely. Definitely. I told it earlier. Just the loan which was taken by the wife on demand of husband falsely taken by the husband from the financial loss. Yes, the wife can claim. Wife can claim that financial loss under DV Act. If a married man marry with another woman, that marriage is invalid according to Hindu Marriage Act. If a married man marry another woman, can second wife claim maintenance? No. Because you are telling second wife, the term second wife is itself illegal. There cannot be any second wife. Only wife. What is second wife? Okay. While the complaint application of 498A at police station is filed, how many days an accused has to prove his innocence to the investigating officer? That is uncertain. That depends on the police. That depends on the police, because it is the part and portion of the investigation. You will get the opportunity to prove your innocence in court. Next, Mr. Siddhant, can a husband file against his wife for domestic violence? Only a woman can file, not a male. Then what are the remedies available to second wife? No remedy. Nothing is available for her. Second wife, there is no term. She will be she may be treated as concubine only and nothing else. Once 490-day FIR is filed, how many days accused to take anticipatory bail from the court? There is nothing as such mentioned that husband can take anticipatory bail within such and such dates. But you have to take an anticipatory bail as soon as possible. That is the only advice. Can a man marry another woman if the marriage is not registered as per Hindu Marriage Act? I could not understand, Mr. Chowkaji Rao. If possible, please explain. Next, if complaint under section 490A is filed, can DVS filed? Yes, can be filed. Both the cases can be filed, because the
sir, if a marriage is performed and it is not been registered,
okay,
so can a husband marry another woman?
No.
Because it is not as per Hindu Marriage Act.
Lots of unregistered.
It should be registered under the Marriage Act, no? Huh? If a marriage is not been registered, then it is not as per Hindu Marriage Act.
That an unregistered marriage is not. Can you say that an unregistered marriage is not a marriage? Can you say?
It's a marriage, but can he marry another marriage?
No.
Which law states that he cannot marry another woman?
No.
No. Which law states that he can marry another woman? Cannot marry another woman.
Hindu Marriage Act. You will
not registered as per Hindu Marriage Act.
Huh?
That's okay. In India, Saptapati is also marriage.
Yeah.
Saptapati is also valid marriage.
It is mentioned in the Hindu Marriage Act only.
No, it is not registered as per Hindu Marriage Act.
That is okay. Saptapati is also done. Then also it's a valid marriage. Always registering marriage is not
parties
necessary.
are Hindu or not.
Huh?
Whether the parties to this marriage, unregistered marriage, are Hindu or not.
Yeah, Hindu.
But sir, according to Hindu Marriage Act, the registration of marriage is not compulsory, like in the case of Seema Agarwal, the landmark.
Saptapadi is a valid performance to complete a Hindu marriage.
Sir, I have one doubt, sir.
Yes.
Sir, boy is from Christian community. Sorry, boy is from Hindu community and girl is from Christian community, sir. There is no registration of the marriage, and the marriage was performed in a church, and the church people has given some paper, some. So, whether that marriage is valid?
Yes, valid. Church marriage.
So, if she files one Hindu 125, section 125, is there any problem? Is there? Yeah, she can
no problem.
File,
you have to produce the church document. The church document is enough.
Okay. Thank you, sir.
Okay. Any other question?
Yes, sir. One question.
Yes, sir.
Means like we are seeing that so many false cases are being filed by wife on the husband and their families, And so it's the cases are so means the list is very very long. So is government doing anything, or any lawmakers are doing anything related to this, so that we can save our families and all?
Government are planning to make it a billable offense.
That is a matter of research, and what the government is doing, what the parliament is doing, I cannot say. But in my practice, I found lots of false cases. The Chief Justice of India repeatedly told about these false prosecutions, misuse of law. But I don't know what the government is doing, what the parliament is doing, what the law judiciary is doing. I don't know.
Excuse me, sir. Sir, another
So
question.
can I
sir.
add to this? So can I add to this whatever you have told now, what government is doing? Although we really don't know what government is doing, but to answer the question, as 498 was initially was non-bailable offense, then it became a bailable offense. There was a relaxation after one judgment. If you have heard yesterday's session, the sir in yesterday's session has highlighted, and as judiciary, as our law says, 100 culprits, if they set free, is okay, but one innocent person should not be victimized. Yeah, so that's the reason. Things are not taking at a speedy pace, but there are relaxations. 498 has become very, very relaxed now. Arrest is not happening. Bailable, immediate bails are getting. So these are the steps which are taken towards supporting men. This I can just add to.
What I can add to it?
I don't think so.
Yesterday, sir has shown some graphs like male committing suicides. So what is the relaxation here? Where is the relaxation?
Yeah, but initially in 498 cases, immediate
I
arrest.
don't think, just a minute. Gentlemen, just a minute. I don't think that the mandatory issuance of 41A is positive steps towards giving relief to the husbands. Rather, it is a relief for the investigators. This much I can say. If you can understand.
Sir, another question, sir, please. If a husband is insolvent, can a wife demand in maintenance the property of mother-in-law or insolvent?
No. If it is court declared insolvency, no demand will lie.
Okay, sir.
Just read the cases of Bombay High Court, that industry অভিজিৎ সরকার versus CBI, Bombay High Court. অভিজিৎ সরকার.
Okay, sir. Thank you, sir.
অভিজিৎ সরকার versus CBI, অভিজিৎ সরকার versus State Bank of India, and অভিজিৎ সরকার versus, if I am not wrong, Allahabad Bank. Just search with অভিজিৎ সরকার, you will find lots of cases.
Okay, sir.
অভিজিৎ সরকার is declared insolvent.
Understood.
Anything else?
So, sir, one small question, sir. Sir, actually, husband and wife both are government employees, and wife is right now residing at the flat which is EMIs are paid by the husband, and they have 2 kids. So the wife has claimed the maintenance for the kids, but the husband is giving all the food items, clothes item, and paying the EMI, maintenance, everything. So can this maintenance will be given, interim maintenance may be given to wife?
Should not be allowed.
So means we have to give the counter on that one.
Definitely. And you have to show the proof that I am paying for everything.
Yes, sir. EMI is everything is through salary account only. Everything is going, and husband is giving the food items and the clothes and dolls. Everything is giving, sir.
You have to show the proof for that.
Yes, sir. Everything is on Amazon only.
And
So
then you have solid proof of it.
Yes.
Good evening, sir.
Then you have solid proof of it.
Yes, sir. EMI is everything is through salary account only. Everything is going, and yes, EMI only, through EMI only. Salary from the salary only is
Then
deducted.
you have recorded proof.
Yes, sir.
Then no need to worry.
And the problem, and one more thing is that wife. One more question, sir. That wife, husband has filed Juvenile Justice Act, JJ Act on wife. That wife has beaten Juvenile Justice Act, JJ Act, 21, Section 21 of Juvenile Justice Act, because the wife beaten son with iron belt, the school iron belt, and he got some grievous hurt. But right now the kids are with the mother only, because the police people telling that mother is the natural guardian, and she should take care of the kids.
Immediately filed case under section 326 or 325 against the wife, and filed a case under Guardians and Wards Act with the prayer for temporary custody.
Yes, sir.
You will get relief, and along with that, file one petition for immediate direction to produce the child before the learned court for interview.
And sir, I want to add just another point. Sir, I think sir, father is the natural guardian.
I cannot hear you.
Sir, I think the father is the natural guardian in case of Hindu.
Oh.
Father, sir. Mother is not the natural guardian.
I cannot hear you. Please be louder.
So there is like now 8 o'clock. The session should was till 7:30. So
yeah.
So I'll just ask one last question, sir. So in income asset liability, if wife is concealing mutual funds and other income sources, and she has FD and other things, and she's concealing, and interim maintenance application is filed, and the husband has the evidence related to mutual funds and FDs and all that. So what is the which is the best time to file the perjury, or should he go for perjury? And if yes, which is the best time to file it, before the interim maintenance order gets passed, or after it?
After closure of the case.
After closure of the case, okay.
Yes, not before that.
Good evening, sir.
Good evening.
I have a know the steps. Suppose some of the act which is falsely or misused, or
your voice is dropping.
Sir, is it clear now?
Yeah.
Hello?
Yeah.
Actually, I'm asking that suppose some acts are there that has been misused or falsely used for the society. So changing that one, what is the actual step-by-step process? How it can be modified? Can you please explain so it can be
modification of what?
Act like 498 has been getting misuse, or any other act. So
that is not the subject matter of today's session. That is not the subject matter of today's session.
Okay, fine.
I am sorry.
Okay. Can you help me out to where I can get that, sir? Just suggestion.
You will get various research papers on ResearchGate on this point, or academia.
Okay. Thank you very much. Thank you very much.
Anyone else?
So we are at the verge of ending this session, sir. Thank you so much, everyone, for asking questions, and thank you so much, sir, for taking everyone's and answering everyone's question. So we wrap up this session here only. I thank you, Professor Prithwish, for this enlightening session. I'm sure everybody would have found your insights and expertise valuable and informative. I thank all the participants for being cooperative during the session. Thank you all for joining.
Thank you so much, sir, for such an enlightening session. It was pleasure having you on our platform.
Thank you.
Thank you, participants, for being cooperative. Please be there for the third session itself.